I'm delighted to see you all here today for the second day of this conference. We were just discussing after the conference yesterday what a wonderful success we thought it was. They had the fabulous papers, very, very interesting, and all of the great discussion that went along with it. And we're really looking forward to the second day of our conference. So today we have three panels. They will be health and emergency, the rule of law and accountability, and economy and workers. Can I ask you please that if your microphone is not yet muted, would you turn it on to mute please so that we don't get feedback? And also to ask you that when you have questions, to please write them in the chat function so that we can see them. So without further ado, let me introduce please Dr. Paula O'Brien, my colleague at the Melbourne Law School, and to welcome her as the chair of the Health and Emergency Panel. Over to you, Paula.
Thanks very much, Sarah, and welcome back everybody for day 2 of the conference. It was a fantastic day yesterday, and I felt like I learned so much from listening to all the presentations and from the questions as well that were coming through the chat. So thanks to everyone for contributing to such a vibrant set of sessions yesterday, and I look forward very much to how we're going to go today and expecting the same kind of fantastic day. So this panel this morning is on health and emergency powers, and we're going to follow the same format as yesterday. So I have a question for each of the 3 speakers, and I'd ask them to stick to the 3 minutes in answering the question so that we have plenty of time for good group discussion. The papers this morning all converge around a theme of the adequacy of the domestic or international legal architecture for controlling the response by states to COVID-19 and for ensuring that that response is effective, it protects rights, and it is consistent with the rule of law. And we're really very fortunate to have excellent papers from colleagues from Vietnam, Indonesia, Canada, and Australia on this panel. And we're also very fortunate that several of those papers also introduce comparative material from additional countries, such as Hong Kong, Russia, the Republic of Korea, and Thailand, just to name a few. So I really commend the speakers' papers to you, and they are on the website, so please go and read them. I'm going to give you a short overview of the papers now for those who might not have had a chance to read them, but to also refresh the memory of those who have read them a little while ago, and so that you can have the paper front of mind as we go through this session. So firstly, we have a paper from Professor Ahn, who discusses the concept of legal hazards which arise during a time of emergency. And the paper deals with many different country contexts and the mechanisms for preventing and redressing excesses of executive power. He also presents a really fascinating argument that I'm going to ask him to talk more about. And that's an argument about the possibility of harnessing self-governance of the family and the community as an alternative and highly effective mechanism for preventing the spread of pandemics like COVID-19. Our second paper in the session this morning is by Professor Melboume, and he addresses the legal frameworks within Australia's federal system of government for the executive's response to COVID-19. And he argues that the experience with COVID-19 shows the wisdom of primary responsibility for public health aspects of infectious disease control lying with the states and territories in Australia. So in other countries that would be called the provincial level of government, as opposed to infectious disease control responsibility lying with the national or federal level of government. And he expresses the view that the local conditions in each state, territory or province justify a different response to COVID-19, especially in relation to removing restrictions so as to avoid a second wave of infections, which we know is a concern in countries around the world. Our third paper is from Professor Lafrance, and it describes the Canadian government's powers under the Emergencies Act, which to date have not been invoked, in recognition of the capacity of the provinces in Canada to exercise powers to respond to COVID-19. However, exercises of power by either the federal level of government or the provincial level of government raises serious questions about consistency with the Canadian Charter of Rights and Freedoms and its provincial equivalents, and the circumstances under which governments are entitled at law to depart from these constitutional standards. We next have Professor Tai and Professor Hall's paper, which outlines the legal framework in Vietnam for responding to emergencies. And this framework presents a mesh of different actors exercising powers, making declarations, deciding on measures, and implementing those measures. And the authors argue that although in practical terms, so very importantly in practical terms, Vietnam's response to COVID-19 has been highly effective, there are flaws in Vietnam's legal architecture which have been revealed in this crisis and which need to be redressed for the future. Our fifth paper is by Professor Mai, and Professor Mai brings our attention up to the international law level. And the paper argues about the relevance of international law to the current circumstances. Professor Mai examines the requirements for derogation under a number of international legal instruments and argues that international human rights regimes lack clarity and consistency about the extent to which rights can be lawfully derogated from in times of emergency. Our final paper is by Professor Wiratraman from Indonesia, and the professor critiques the Indonesian government's handling of COVID-19, including the fractures in the legal response, the inadequacy of the response, particularly in terms of economic protections for citizens, the dearth of honest information to citizens, the rejection of science, and the failure to protect rights, as well as several instances of very worrying positive violations of rights by the state. And the paper argues that all of these deficiencies are departures from the standards expected in a rule of law system. Okay, so with that summary under our belt, I'd now like to put the questions to our expert panel this morning. So we're going to start with Professor An from the Vietnam University. And in your paper, State of Epidemic Emergency in the Law of Vietnam and a Number of Countries in the World, you suggest that self-governance within the family and in community have been as effective in the fight against COVID-19 as some state interventions. Would you be able to tell us more about these self-governance acts within the family and the community? Why you think people have so willingly engaged in such acts, why they've been effective, and whether you think these are approaches which work in certain political and cultural contexts, but not others. Thank you, Professor An.
Good morning, everyone. Thank you very much for overview. It's a conference, and thank you, Paula, for the comment on my paper. Come back to the questions. Yeah, I'm very glad that you raised the question about my paper, because I think it's an idea that I love very much. This self-governance from the family and the community. And the first thing you asked me, can I give some more example about this self-governance? Yes, in Vietnam, during the COVID-19, we have some example very popular about this mechanism. For example, the ATM riser is very famous in Vietnam. This an initiative, an idea from the community, when the community donate the rice through an anonymous source for the people in need, for the poor people. It's very popular in the very big city in Vietnam, like Hanoi and Ho Chi Minh. Second thing, what what I can talk about the role of family and the community in during the social distancing. It's very important because during this period, each family keep their children and remember, especially the elders inside, very effectively, and regularly update on their family member health status for the government. It's very good. And the role of community in this period is very important because some community lockdowns with some epidemic, especially in the area of village that had no exposure to the infected civilian, and these communities completely isolated during the lockdown process. That means what I want to say. The people from this community can do something like barrier to self-defense to control the people from outside. It's very good. They don't need about something from the government. They can control the village themselves. And the last thing to say about the role of family and community in this period, that's the sharing experience on virtual platform. It's very popular. Especially on Facebook, we have very viral trends around wash your hands songs, very popular, and wash your hands dance, very popular. The showbiz in Vietnam also raise awareness using their platform. That's something very strong from the community. That's why I think during the COVID-19, the role of community and the family is very important.
Okay.
Come back to our question. The second thing you want to ask, why I want to focus on this community and family. Yes, I think Vietnam, we has successful control the epidemic till now. It's very important, the role of government. But also in my paper, I want to focus on the role of family for some reasons. The first thing, economical reason. The government has the modest budget for because Vietnam is a developing country, so the budget is modest. So the strategy from the beginning had always been a collaborator from the government and the citizen. So we can call the support from the community, from the family. It's very good. So this is for economical reason. And the second thing is for the reason of culture. You know, in the Asia country, the Confucianism tradition is very important. So it will give the priority for the public over the individual. People and so well informed and have a deep trust towards the community and their family. So the family and community play the important role in social distancing now.
I'm sorry, we've gone a little bit over the 3 minutes. So if I can just get you to hold the last part of the answer, and maybe in the discussion time, we can hopefully come back to it. So thank you very much for the answer so far. That's wonderful.
Okay, thank you.
Great. So we'll now put a question to Professor Lieberman from Melbourne Law School. And in your paper, Frameworks for Australia's COVID-19 Emergency Public Health Response, you were very positive about the Australian states and territories being given primary responsibility for the response to COVID-19. Would you be able to elaborate on why you think federalism has worked well in Australia in the context of the pandemic, but to also highlight any challenges of this approach? Thank you.
Thank you very much, Dr. O'Brien. And can I also thank the organisers of the conference? It's really fantastic to learn from you all from so many different countries. Let me know if I go too long. So very quickly, Australia has 6 states and 2 territories, and we have a national government, and there's ongoing tension across almost all policy issues of what should be done at the national level and what should be done at the state and territory level. At the state and territory level, public health units have primary responsibility for infectious disease control, and at the national level, the national government has responsibility for the management of biosecurity threats, which include human biosecurity. So for COVID-19, there are both the Commonwealth and the states and territories have power, and that power significantly overlaps. So my main point, and I've included some data in the paper, is that you can see that the number of cases really varies across the different states and territories. As of a few days ago in New South Wales, the highest, the population with the largest state, the state with the largest population, there were 3,110 cases. And in the Northern Territory, which is probably our smallest, has the smallest population, there were 29 cases. So what makes sense for one jurisdiction doesn't necessarily make sense for other jurisdictions. And when we think about the real lockdown measures, so these are restrictions on whether people are allowed to leave their homes and whether cafes, restaurants are open, fitness centres, beaches and so on. Those have been introduced at state and territory level rather than at national level. And because these are all such significant restrictions on our ordinary way of life, it's important that those aren't any more than is needed by the evidence. So what is needed in New South Wales and Victoria is very different from what's needed in the Northern Territory or the Australian Capital Territory. One of the challenges, I think, though, is that much of our media is national, and much of the public communication about COVID-19 has come from our national leaders. So we have people in states, so I'll take Victoria, which is where we are in Melbourne. I think it's fair to say that the Victorian government has probably been the most cautious. So from the beginning has probably had the strongest messaging about the public health seriousness of COVID-19 and the most cautious in opening up from the lockdown. And I think that what's happened is people have then looked at other states and territories that have been opening up more quickly and have been critical of Victoria for being too cautious or too slow. Now, I'm quite critical of that approach. I think, firstly, Victoria needs to do what makes most sense for Victoria. And it may be that the other states and territories are opening up too quickly. So I think it's just a point about being careful in the comparisons that are drawn across jurisdictions where what's happening in each jurisdiction is quite different. And also the public health capacity to deal with COVID-19 is different in different places.
Thanks very much, Professor Lieberman. Okay, our next speaker today is Professor Lafrance from the Public Prosecution Service of Canada. And in your paper, The State of Health Emergency and Fundamental Rights and Freedoms in Canada, you raise the very important question of how constitutional protections of rights and freedoms operate in these times of public health emergency. And you point to the capacity for lawful restrictions to be placed on these rights. Could you discuss how the Canadian courts have adjudicated, or you think they would adjudicate, any matters relating to restrictions on rights in the time of COVID-19? Thank you.
Thank you very much. Do you hear me okay?
Yes, that's great.
Fantastic. So first of all, thank you very, very much for organizing this amazing presentation at this amazing international conference. I'm really happy to be among all of you today. Briefly, I just need to tell you just a short disclaimer that everything I say is not binding on my job as prosecutor prosecutor for the Public Prosecution Service of Canada, but just on my behalf that I'm here today. To answer your question, there are 3 points, and I will make them very briefly, so less than 1 minute per point. The first one is history. I wrote in my paper that basically now Canada basically never relied on the Emergency Measures Act, but Canada did rely on the War Measures Act, which the current act is greatly inspired from. And there's a historical trauma in Canada where the War Measures Act they were applied during the war, obviously, but also in 1970 when there was a constitutional and political crisis in Canada because of a separatist movement in the province of Quebec. So there's the reason I'm saying this is to make one point, is the Prime Minister, even though the law exists, the Emergency Measures Act, his dad was the Prime Minister in October. The Prime Minister, the current one, his dad was the Prime Minister of the time, and his dad relied on the War Measures Act. So he basically was raised, because he's pretty much my age, he was raised in an environment where relying on such emergency or War Measures Act, whichever way you call it, may cause problems in terms of fundamental rights. That's my point, the first one. The second, there's only so far one case that hit the media so far in terms of breaching fundamental rights in Canada. It's in Newfoundland. Factually speaking, in a few words, the case is there's a lady who wanted to go to her home province. So from Nova Scotia, this is one province. She wanted to go to Newfoundland, which is another province of Canada. We have 10 provinces and 3 territories. And she couldn't. And she wanted to go to Newfoundland because her mom died. And the government told her, no, because of the travel restrictions, you cannot come to Newfoundland. And this case was brought to court. So it asked, and that moves us on to the third point that I want to make, that is intertwined with a second. There is some tension, exactly like in Australia. I was actually flabbergasted, I must say, that the issues that Professor Lieberman was talking about, we do have the exact, at least their nature, we do have in Canada the exact same issues. In terms of the division of powers between the subdivisions, the provinces, and the national government. So there are 2 ways to go back to the second and third point. There are 2 ways to approach this case. So basically, based on Section 6 of the Canadian Charter of Rights and Freedoms, you are free to go wherever you want inside the country. Their liberty, freedom of movement, basically. But here, how could you challenge it potentially? And it's only potentially. It's either from the fact that the division of power was not complied with, because basically does a province can limit the freedom of movement, or it is of federal jurisdiction. So that's a way where the court would not be deferential or respectful, between quotes, to be understood. So would not be differential towards the governmental decision, because that would be analyzed through the administrative law spectrum, and based on the 2019 Supreme Court of Canada decision in Vavilov, there's no deference for the government's decision. So if we approach this decision from the administrative law perspective, no deference, it can be challenged just in the eyes of, in the light of the division of powers. And to conclude, if we approach it from the other end, from the end of a charter breach, and I finish my third point and my time will be up soon, but if we approach the same issue, the same factual basis, but from the perspective of a charter breach. So Section 6 was breached, and this is not the division of powers which is challenged, meaning was the government allowed to make such a decision of restricting travel? But if we focus on the breach itself of the freedom of movement, then it becomes more complicated, because it's a 2-step analysis, and very summarily, because we don't have much time, but very summarily, when there is a breach, and if there's a breach, not acknowledging the existence of a breach. But let's say, yes, Canada or the province breached the freedom of movement. It's a two-step analysis. Then in Canada and other countries as well, fundamental rights are not absolute. So there's, I know it's very similar in Indonesia, for example. So the second step is to look at could the action of the government be justified in a democratic society? And there's a complex test that we will not see today, but one of the, just to finish, 10 seconds, one of the elements that must be looked at and analyzed is, was there an alternative? The minimal impairment of the right. So was there something else to do? So could the government have done something else? So even though it seems pretty simple, my paper is not very long, the issues are complex, and also depending on the glasses you wear, administrative law or fundamental rights, purely fundamental rights, the analysis will be different, and also the spectrum of analysis would be totally something else. Thank you very much.
Okay, thank you very much, Professor Lafrance. So we now move to the paper by Professors Tai and Huao, and in your paper, Authority and Procedures for Declaring an Emergency under the Law of Vietnam and Matters Raised, you argued quite strongly that there are flaws in Vietnam's legal architecture which have been revealed in this crisis and which need to be remedied for the future. Could you explain to us what reforms you would suggest to ensure that Vietnam has an appropriate legal architecture for responding to emergencies? And are there models from other countries which you recommend for Vietnam? Thank you very much.
Tai and Professor Hoa can be here to answer directly your question. So on behalf of them, I will present the answer. Yeah, in their opinion, it's necessary to enact a law on the state of emergency to replace the ordinance on the state of emergency to ensure the compliance with the 2013 Constitution. This law will provide special emergency measures, protection of social interests, national security, as well as to the protection of human rights. Within the scope of research, our paper studies the Russian legal framework on the state of emergency. In the case of Russia, I think that some experience can be learned, such as the state of emergency is prescribed in the Constitution and law. The authority to declare an emergency belongs to the President and must be approved by the National Assembly to ensure the control over the President's decision. In this conference is a great opportunity for us to learn other international experience. That's the end of the answer. Yeah, thank you very much.
Okay, thank you. Thank you very much for joining us to provide a response to the question when the authors were not available to be here.
Yeah.
Okay, we'll now move to Professor Mai's paper, and in your paper entitled The Limitation for an Emergency Situation to Protect Rights, your argument is that there is a lack of clarity and consistency in international human rights instruments about a state's entitlement to derogate from its obligations under various treaties. So given this, do you think that international human rights law can contribute to the protection of rights in situations of emergency? And how does international human rights law make such a contribution? Thank you very much.
Other international human rights instruments such as ICCPR, ECSR meet challenges when the nation declares a state of emergency, such as determine the existence of a public emergency. More specifically, in this instrument, the use of expressions such as threats to the life of the nation. Sometimes this regulation implies that states will determine whether the life is threatened by a public emergency, because this is respect for national sovereignty. Its government will do its best to protect the life of its nation. Maybe that's why ECTSR accepted that the threat of international terrorism war and emergency threatening the life of the nation in the UK after the 9 November terrorist attacks in the US. Although the Al-Qaeda terrorist attacks has taken place outside of the territories of the United Kingdom, and the UK was the only European state to make a derogation under Article 15 ECSR. More is the case of ECTSR that I have analyzed in this paper, empowering the courts to assess whether the measure taken by the government to derogate the right exceeds the strict requirement of the situation. In ECTSR cases, the court has a view that the defendants, Islamic countries, violated the right in ECSR. These remarks will then serve as a legal basis to govern the behavior of subsequent states with similar situations when declaring a state of emergency and being vigilant in taking measures to suspend rights. Not only that, but also it is an experience for Vietnam to develop the law of state of emergency and apply the law during a state of emergencies. This is my point. Thanks for listening to my answer.
Okay, thank you. Thank you very much for your answer to the question. That's very helpful to the discussion. We come to our last paper for the session, and that's the paper from Professor Wiratraman from Erlangga University in Indonesia. And in your paper entitled, "Does Indonesian COVID-19 Emergency Law Secure the Rule of Law and Human Rights?" you raise very serious concerns about your state's conduct in the time of COVID-19. And do you consider that the experience during COVID-19 holds any potential for change in the way that the Indonesian legal and political system operates more generally? And do you think that COVID-19 and the situation in which Indonesia finds itself could be a spark for wider reforms in the future? Thank you very much, Professor.
Thank you, Paula, Obreen. And good morning, everyone. First of all, I would like to thanks for the organizer, PNU and UNIMEP, who organized this conference. Really appreciate for that. Responding to the questions, I have comments on this issue, especially looking at the Indonesian government took denials in the very beginning and start making emergency situation actually in the end of March 2020. And during those times, actually, anti-scientism has been taking place, such as rejecting the argument that the virus had been affecting the community, although no confirmed COVID cases. It might be a quote-unquote a false negative in medical statement, since the government has no capacity actually to test in early infected situations. During the COVID pandemic, there had been a lot of pressures on civil liberties. As I provided, I took 10 legal cases during pandemic situations. However, this unsurprisingly, since I published actually 2 years ago, an article on the rise of authoritarianism in Indonesia. Hence, actually, this is explaining first why the COVID-19 actually response had been dominated by military officials in managing emergency situations rather than those who are experts on health issues. Secondly, legitimate criticism, not only issue of democracy, rights, and social justice, but also the threats on issues like criticizing the increasing curve, the dangers of annulment of social distancing policies, as well as prediction of quote-unquote herd immunity in current health emergency situations. And the third, the government message in announcing quote-unquote new normal although it does not fit to the World Health Organization's requirements, seems to another direction for disciplining civil society criticism, as well as providing evidence to enlarge distrust to how the government actually handle the COVID situations. By these facts, actually, what will be criticism in response to the Indonesian legal and political system operate generally in handling pandemic? First, this will be sort of the continuation of democracy decline by applying anti-democratic and also restrictive policies. The only difference is the use of public health emergency as a legal basis. Secondly, under the current and new legal instruments, during emergency situations would enable the government to take policies without proper accountability, since it adopts immunity for those who use state budget in the name of responding COVID-19 pandemic. Hence, this could be legalized corruption in the new model system of legislations. And the third, of course, human rights issues will be at more serious risk. And your last questions, could the COVID-19 situation be a spark for wider reforms? I will argue that to see this actually is more consolidated for oligarch network for securing their vested interest in controlling political economy resources. That's all. Thank you.
Okay, thank you very much for that response. It was really fascinating. What I'd like to do now is we have about 15 minutes for some discussion, and we've got some great questions coming through in the chat. I'm going to try and put a question to each author, even though there are multiple questions to some authors, but I thought to give each presenter a bit more of a chance to talk about their work. So if I don't, I will go down the list, but I might skip over a question to get to the chance to give each person another say about their paper. So we'll start with a question to Professor An, and the question says, your paper highlights Vietnam's experience, which is to promote the autonomy of the family and the community to replace traditional legal surveillance mechanisms that prove ineffective in an emergency situation. On the other hand, you argue that there are major concerns posed for the post-pandemic period, whether abuse of power trends could remain. Please share your opinion about whether the solution to promote the autonomy of the family and the community is a long-term solution or just an instant in times of crisis. What are the possible consequences in that case? So thank you, Kwan Duc, for that question. And Professor An, if you could give a short response.
Yeah. Thank you for the question. In fact, I think the promoting of the community and family roles in every activity is very important. It's a trend today for the state governance. It's not only in the epidemic period, but it's general. And how to promote it, I think it's a participation direct mechanism. And the state have to encourage many initiatives from the community and from the family. But come back to the control, how to control the abuse of power from the state. We also use the traditional method like the legislative control, the judicial control. For example, the constitutional courts, the administrative courts, they can judge some government activities during the emergency state period. Yes, for the first question. That's all.
Okay, thank you very much for your answer, and thank you for the question as well. I'll now move to a question for Professor Lieberman. So I can see that Professor Lieberman's answered a question of Professor Tuan in the chat. So I might move to the questions of Professor Lee to Professor Lieberman. And Professor Lee asks, how different are the political leanings of the various state and territory governments in Australia, and how do these differences in political leanings manifest in the way the states and territories are responding to COVID-19? And have there been any instances of government overreach? Thanks, Professor Lieberman.
Thank you for the question. I think that first one is a really, really difficult to answer. But we do have two major parties here, the Liberal Party, and there's a coalition in some states between the Liberals and the Nationals, and we have the Labor Party, and we do have different parties that are in power in different states and territories at the moment. I don't see any difference yet. I think it's something that it would be interesting to watch. It might emerge over a period of time, but I hadn't thought about it until I read your question in this way. I think that pandemic challenges some of our assumptions about how different political parties regard different kinds of rights. So to say, I'll try to do this at a fairly general level, and if either Paula or Sarah want to add, please do. So I think, broadly speaking, our Labor Party is seen as more concerned about public health and about economic, social rights, more progressive, to act earlier, and in so doing infringe on people's rights in pursuing public health. And I think the other side, Liberal National, in many ways, they're seen as more, and these are generalizations, they're seen as more concerned about the economy than about health and social rights. But many elements of that party are probably also more in favour of government surveillance of different kinds. So it's a really fascinating question about how what's different about the pandemic challenges our ideas of what different parties stand for. So I'd be interested, I'll just answer the other question. I'm interested if there's time for Paula or Sarah to add. So I think there have been cases of overreach, I think more in enforcement of legislation and regulation. I think one of the really challenging things about the way in which laws and regulations have been introduced through the pandemic is that they've had to be introduced so quickly and changing all the time that I think in many cases people actually don't know what the law is. And so I think in some instances enforcement might have been better done by way of talking to someone or warning someone than necessarily issuing a fine. And I think the other part, I think Paula will talk about this a bit more in her presentation. I think in Australia we don't have a lot of opportunity for challenge in the courts, or not as much as in many other countries, because we don't have many rights in our constitution. We don't have a Bill of Rights, so there can still be a range of administrative law challenges. But I think Paula will talk about different ways of exercising political accountability in Australia.
Okay, thanks very much, Professor Lieberman. So why don't we move to the next question, which is for Professor Hulabangang, and it says, thank you for your paper. Could you please explain more about the differences in the authority to declare a state of emergency between Law 23 from 1959, Law 24 from 2007, and Law 7 from 2012, and then Law 6 from 2018, the 4 laws that you mentioned in your paper? And do these laws have any conflict of authority relating to human rights protections? Thank you.
Precisely correct in mentioning the law. Yes, of course, there are several differences, and I already described in the paper making a column. So I try to make it detailed. For instance, like Law 23 of 1959, it should be declared by the president, and also different to the law in 2007, it can be declared by a president as well as the city mayor. It depends on the context of disaster. And also in 2012, law on social conflict should be declared by the president, governor, or city mayor. And the last one must be a president. It depends, again, it depends of the level. But the point that I would like to share here is related to what extent adopting human rights principles in these laws. The law on 1959 actually is the oldest legal framework for emergency power in Indonesia. Of course, less adoption for human rights, and it was enacted prior to International Covenant on Civil and Political Rights. So it's really limited to mention about human rights. But the other, interestingly, arguing about the more state obligation in providing, for instance, like securing human rights, providing basic needs, or protecting social economic life. And these are really new development and important to be considered to what extent actually those emergency powers related.
Okay, thank you very much for that answer. So I think we'll have time for just one last question, which is lovely because we can go to Professor Mai. And there's a question to you, Professor Mai, about could you explain a little more about the principle of proportionality in determining the limits of measures to be taken when declaring an emergency? And the person asking the question refers to section 1.2. So if you could answer that question, that would be great.
My name is Pham. I'm come from the Hanoi Law University, and I am co-author this article with Dr. Mai, and she my leader. And I'm going to answer the question about the principle of proportionality. In my article, I have analyzed some issue from this principle to declare the state of emergency and how it limits the human right. And one of the measures to control the power of a country to declare the state of emergencies is the principle of proportionality. The condition of proportionality is issued in some international treaty. For example, Article 4 in ACCPR, Article 15 in ACHR, and Article 27 in ACHR. And it requires that the measures must be suitable for the objective and that it being pursued, and it must not go beyond that is necessary to achieve the goal intended. And it's a principle of proportionality. And in the morning yesterday, a professor that has examined the requirement of step to evaluate the proportionality in declare the state of emergency. And in my article, I clarify some issue and a case of in United Kingdom to prove my point of view. So thank you.
Thank you very much for your answer. You'll all see in the chat there's a number of other great questions that we're unfortunately not going to have time to get to, but hopefully the authors will think about the questions and may want to communicate with the person asking them directly, or they may be things that we can also pick up in the discussion section at the end of the conference today. So I would like to say thank you to all the presenters in the session for your excellent papers and for the discussion that we had, which really has taken the conference another step forward this morning in our understanding of emergency powers in COVID-19 in countries around the world. Thank you very much.